Hi folks, and welcome back to Contract Law. This is the video series on vitiating factors, and in this particular series we are going to be having a look at mistake. So here we are in the present, and you can see there's been a terrible mistake there with what looks to be like a Lego Titanic. I thought the iceberg graphic was rather good for mistake. Often it's the things you don't see that really can trip you up so far as contract law is concerned. Now, let's have a little look at where we're going and what we're doing today. We are doing mistake today, and mistake really is the first of the vitiating factors that starts to explore for us certain concepts in equity. So we'll be looking a little bit at equity today. And we'll be looking at the three main forms of mistake, which is common mistake, mutual mistake, and unilateral mistake. So that is the plan. Before we start looking at the principles around mistake in substance, we really need to look at remedies and terminology issues first, because, as I said, equity does creep into play here, and a lot of you will not yet have had a chance to do the equity and trusts unit. So what we're going to look at today is just a very 25-word or less overview of where equity is kind of coming from, so that you can get a little bit better understanding of equity and how it cuts across what we look at in contract law. So you will no doubt remember from your Intro to Law unit that the common law arose from basically an attempt to get a little bit of consistency into the law of England. Before the Norman Conquest, there was just a whole stack of different kinds of customary laws that applied in all the various little shires and counties. And quaint as it might have been, it was rather frustrating because there was, as I said, no consistency across the land, which meant that, you know, the quality and levels of justice being meted out amongst the various different counties and shires wasn't as even-handed as it might have been. So from about the 12th century onwards, King Henry sent judges around on their circuits to administer justice in the various different parts of England. They tried to achieve consistency in their decision making, and hence we had the common law evolving. It was common across England and therefore more desirable. However, as with all good things, it had its disadvantageous aspects, I guess you would say. Because of that drive for consistency, there was a level of inflexibility that was associated with common law actions, and in particular there was a whole lot of formalities around the old forms of writ that had to be complied with before you could actually run an action, and there was a very limited number of forms of action that were available, and because of the very stiff and rigid adherence to process and formality in the common law courts, justice was denied to many. There was a whole lot of people that came to court expecting some form of remedy, and the common law just wasn't able to provide it, either because of problems, as I said, with process, not complying with the writs, or because you couldn't fit your cause of action within the forms of action that were available. And so therefore we had people getting rather ticked off that they couldn't get a remedy and marching off to petition the king, who then unsurprisingly delegated the task to the Lord Chancellor. So by about the 1300s, we have the Lord Chancellor establishing a court that was driven very much by equity and good conscience. Particularly ideas of fairness were paramount in courts of equity. equitable maxims, you'll learn a lot more about those in the Equity and Trusts unit. The maxims that guide the application of equitable principles, so far as we're concerned, the big ones are equity follows the common law, and one who comes to equity must come with clean hands, and that kind of goes hand in hand, no pun intended, with one who seeks equity must do equity. So you can see just from those little set maxims or little mini principles there that equity is very much concerned with doing the right thing. Okay, you give things the smell test. If you can smell naughtiness in the wind there, then in all likelihood equity will come in and swoop the innocent party up to try and give them a remedy. Now, straight away, even just with that very unacceptable and patchy explanation of, the way that the courts of equity arose, you will see that there's a natural tension between the principles that get applied at common law and the principles that get applied in equity. And there was a perception that the courts of equity were really starting to undercut the common law courts. And there was not a war of words, but I guess there was a war of words between those two venerable courts. And by 1873, we had Parliament stepping in to kind of blow the umpire's whistle, and the Judicature Acts established a single court that could administer both common law and equitable principles. And unsurprisingly, Australia transplanted that legislation over here, and we have a fused system of common law and equity here as well. That is not to say that the tension has completely dissipated between common law principles and equitable principles, and we'll see that in fact come out when we discuss the various different principles around common law mistake particularly. So that is an impossibly short and completely unacceptable summary there, but hopefully it might refresh your memory from Introduction to Law, and it'll be enough to go on with for our purposes in contract. Now here's just a little table of outcomes that I've drawn up for you. Hopefully we won't talk about it too much right now, but hopefully if you go back and revisit it at the end of this set of slides, it will make things fall into place a little bit more for you. But the big thing we want to talk about today really is the difference between contracts that are void at common law and contracts that are voidable in equity. Okay. So when we're thinking about mistake as a legal concept, why have I got a block of Swiss cheese there? Because the default position will be like the actual Swiss cheese. The blanket answer when you run a case of mistake will usually be, sorry, we can't help you. Obviously, as you can see on the slide there, due to the need to protect the certainty and reliability of contracts, there's a policy view that you can't just back out of a contract by saying, whoops, my mistake. It would throw the whole fabric of contracting and commercial reliability kind of out of kilter. So I kind of think of mistake as, just those few little holes that you get in the slice of Swiss cheese. Generally, the answer is going to be, no, sorry, you're stuck with the contract. But every now and again, there'll be a little hole drilled through that cheese and you might be successful. There have been a number of additional hurdles to running an argument of mistake, just apart from the general policy stance on these things. The first one is that traditionally it had to be an operative mistake, and that's where the court used to make the distinction between mistakes of fact and mistakes of law. And because everyone was assumed to be aware of what the law says, you couldn't actually back out of a contract for a mistake of law. That has largely been swept away by the David Securities case, and whether it's an argument of fact or law, it's really a dead issue now. So that's kind of by the by. Mistaken motive is a little bit more interesting, and you see why courts say that you can't just back out of a contract for a mistaken motive. What do I mean by mistaken motive? It's where, for example, as the court said in Bell and Lever Brothers, they gave an example of two people that were negotiating to buy and sell a horse, and the horse is just standing there, they're just negotiating. A says, here's my horse, do you want to buy it? B says, how much? A names their price. B says, yes, that's fine. And B goes to lead the horse away, and then he suddenly finds that, whether then or later, the horse is unsound. Okay, the horse's qualities didn't match up to expectations. Now, B would never have bought that horse from A if he had or she had known that the horse was unsound. But that soundness or otherwise of the horse is generally going to be seen as a quality that you had assumed. If you really want to be sure of a particular quality of something that you are purchasing is as you want it to be, then a court would expect you to put a term into the contract itself. Okay, the action for mistake won't necessarily help you out. It might, but probably not. Now, that's mistake as a general legal concept. When you're talking about mistake at common law, the argument ties in with the requirement for agreement, parties to be in agreement about the same subject matter. So consensus ad idem that we learned about earlier on in another video series. So unless the parties have actually agreed and come to some consensus, there's not going to be any contract. Now, if there has been a lack of consensus because one of the parties is mistaken about something quite vital to the contract, then there has been no consensus and the contract will be void ab initio. Void ab initio, or from the beginning. Now, when a common law court says that an argument of mistake is successful and declares that contract void, it has some fairly drastic consequences. It means that the contract, because it has never existed at all, has been a figment of everyone's imagination, then title never shifted from the original owner of the property. No title has ever passed to the purchaser or any other subsequent purchaser. Okay, so you can see if a party decides to sell their goods to a rogue who then quickly sells them off to a third party and then runs off, absconds, you've got a tussle between the original owner of the property and the ultimate third party purchaser at the end of the line, who's probably weighing up those two parties' interests, probably the most innocent of the two, because there's usually something that that original owner could have done to protect their interests and avoid the mistake. So because title has never passed to the rogue and never passed to the ultimate purchaser, that ultimate purchaser, even though they might be probably more innocent, loses out, and the original owner actually gets to keep their goods that they thought they sold to the rogue. So the drastic nature of this outcome really means that a common law court will look very, very carefully at the nature of the mistake that was made, and they will demand that the nature of that mistake will be about something quite fundamental to the contract. It goes to the essence or the root of the contract. Other mistakes around the edges probably won't qualify or be successful in an argument of mistake at common law. And I've given you some attributes of various different mistakes that might be made that don't usually qualify for a successful argument of mistake at common law. So things like creditworthiness, reliability, honesty, age, antecedents, other qualities of the subject matter. A big one there, which I haven't put in, is value. Individual terms of the agreement, usually also. These things, they don't affect the whole contract itself. They're not fundamental. Usually they're just little attributes around the edges that the parties have kind of assumed. So in those circumstances where you're mistaken, not about the whole gist of the contract, but just something around the edges, you're, as I said, normally not going to get up at common law. So the consequence will not be that the contract is void. The consequence will be that it is valid and you will be held to that contract. There has been agreement about the general gist of the contract. There's been consensus, but what you've ended up with is just a bit different to what was intended, and that's unfortunate, and that's usually where you wind up with an argument of mistake at common law. However, where you are looking at mistake in equity, and here you get this tussle going on, the common law has said, no, the mistake's not fundamental enough, you're stuck with it. The big question is, can equity then step in to soften the blow, maybe provide some kind of remedy for the unfortunate mistaken party? In order to enliven equity's jurisdiction, I mean, equity has to have a reason to wade in if the common law would dictate that the contract is valid and the parties should be held to it. So there's got to be some good hook for equity to hang its hat on in order to wade in and start the fight. And here the court will look for some kind of inequitable or unconscionable conduct. If there's that smell test and there's naughtiness in the wind, then that's the kind of thing that will typically throw some circumstances open for equity to intervene. So if that is the case, and equity does decide to wade on in, the court says, yes, we can provide an equitable remedy, it will allow the plaintiff to back out of the contract, or what we call rescind the contract. Okay. However, when you're talking about rescission, you always need to bear in mind that because it's an equitable remedy, the court will always be keeping one eye on the overall justice of the situation, and there are a stack of limitations on the ability to rescind that may get in your way. We call these the bars to rescission, and I've got them in yellow there in the little box on the lower right-hand side. So affirmation, if you've actually said to the other party, oh, look, that's okay, I'm happy to keep going with the contract anyway, you've affirmed it, you then can't go back and rescind. If you have delayed in bringing any action, we call that latches, then unfortunately your action for rescission will be knocked out. If there has been a bona fide purchaser for value without notice, that old third-party purchaser that's a bit more innocent wanders onto the scene, unfortunately then the moment they do that, you will lose your right to rescind. If it's impossible for substantial restitutio to be achieved, what do I mean by that? Whenever you rescind a contract, the court basically unpicks it, they unstitch it, unwind it right back to the very beginning as if it had never existed. Okay, everybody knows it had existed, but what you're trying to do is just kind of unpick it and unroll it and sort everyone out to try and get them back to how they were at the beginning. Now, if that's the case, we call that restitutio in integrum. Where you are achieving rescission in equity, you don't have to get the parties strictly back to their beginning positions. You can make arguments for rescission at common law, but at common law you have to be able to achieve strict restitutio. The parties have to be put back in precisely the same position as they were at the beginning. Usually you won't be able to do that, and the court will have to make some orders. You know, you have to pay Bob $35, and you know, Bob has to give you, you know, everything that you gave him and then something else. I mean, these are orders for restitutio. If you can kind of get the parties back to where they were, equity will be satisfied. So when you rescind, you might ask for orders for restitutio to achieve that unpicking. Other equitable remedies are rectification, where you put your hand up and you say, please, Madam Justice, can you whip out your blue pencil and can you rectify our contract for us? We didn't write it properly because even though we both wanted the same thing, we both came to an agreement on the same thing, the contract doesn't actually say what we thought it said. So can you rectify it, please? That's another big one. And the last one that's, I guess, of interest for us is where, you know, one of the party that's not mistaken then says, no, I actually want you to go ahead and perform this contract. They ask the court for an order for specific performance. You can then counterclaim for refusal of specific performance. So there's some of the ways that equity might rescue the situation for the poor old mistaken party. And that is the basis for mistake as a legal concept. I'm going to finish off the video here, and then in the next video, or videos, we will have a look at the three main types of mistake: common, mutual, and unilateral. So that's it for video 1, guys. Bye for now.